to be a part of this medical legal cases, the topic that you have chosen, the challenges and its mitigation. I'm Anvesha
Thank
Pandey from
you.
NATHEALTH, and I'm so excited to have you all here. Um, this series is being organized exclusively for our members. And we have an eminent panelist with us for this session today. We have Mr. Chakrapani Mishra, we have Mr. Atul Kumar, and Mr. Sudhir Mishra. And let me just formally, read out their short bios and share their bios with you. Mr. Chakrapani Mishra is a partner in the Disputes Resolution Practice Group of the Khaitan and Company. With over two and a half
Thank
decades
you.
of experience in the field, he specializes in commercial disputes resolution. He regularly contributes to various international and domestic publications on litigation, arbitration, and other current legal issues of importance. He has also received many awards and recognitions of international fame. 2014 edition of Asia Law's Leading Lawyers publication mentioned him as one of the most highly acclaimed legal experts of the Asia Pacific region. A very warm welcome to you, sir. We also have Mr. Atul Kumar, partner at Indus Law Associates, is an advocate on record with the Supreme Court of India and has over 21 years of experience in the legal field. He has been advising wide array of multinational and domestic clients on corporate litigation and arbitration matters. He has advised companies and government bodies on healthcare and medicine matters, drugs and cosmetic laws, IPR laws, companies laws, and many more. A very warm welcome to you, sir. We also have Mr. Sudhir Mishra, who will be moderating today's session. He is a leading and an eminent environmental lawyer of the Supreme Court of India. He's also the founder and managing partner of Trust Legal Advocates and Consultants, a pioneering firm in the field of environment, healthcare, and broadcasting laws, which has been ranked 37th in the RSG Top 50 India law firms. He's also been called to number 5 barristers' chambers in the United Kingdom as a door tenant for his exemplary services in the field of climate change. Mr. Mishra was the India chair of New York State Bar Association. He also sits in the advisory boards of leading media companies, including Business World, and has worked for Amazon, TCS, Z, ABP Network, and many more. A very warm welcome to you, sir. And I also welcome our members, our participants who have joined for today's session. We have representation from Fortis, Manipal, Regency, Neothea, King's Hospital, Navneet Hospital, Nursing Associations, and many other representatives have been joining. There are medtech and some diagnostic industries also with us who have joined from different locations all over India. Um, Without taking much of our time, I would now request you, Mr. Mishra, to take the discussion forward. Over to you. Sir, you're on mute.
Thank you, Anvesha. Thanks for this warm introduction for all of us. And I hope I'm loud and clear. And I am very, very pleased to be part of this panel and to moderate this panel, which has Chakrapani Mishra, one of the most eminent litigation lawyer in Mumbai. And we have Atul Kumar, who is one of the most eminent lawyer in Delhi Supreme Court, but also the fact that he is represented before statutory authorities like Delhi Medical Council and Medical Council of India on a regular basis. So welcome all of you as part of the NatHealth team, as part of the NatHealth family. I welcome for this, uh, I would call it a program which has elements of law and medical field, but the more importantly, this is not something which is adversarial for us for the first time. Normally, when we are in the courts, we have adversarial litigations. We lead. Me and Chakrapani and Atul all are on the same side today. And our job is, which Anvesha has given us, to demystify all these issues which govern medical negligence. So I welcome my co-panelist. And before um, we get into the debate today, I can see we have a very, very wide participation. They are industry veterans, industry experts who understand medical devices, healthcare, hospitals, diagnostic. Let me tell you that for me personally, for 20 years, I have been working in the field. One of the few cases which I did in 1999, 2000 went right from district forum right up to the National Consumer Forum. And later, when I started advising hospitals on acquisitions and other important issues like their joint ventures and other aspects, I have worked very closely with the doctors, and here there is a word of caution from my side that I have never worked for patients actually. I have mostly worked for doctors and hospitals and the associations which represent doctors. So that's what my background is. Chakrapani Mishra is one of the most eminent lawyer in Mumbai. He will introduce himself, and then Atul will introduce. So our job is very clear. We will speak for 10 to 15 minutes. We'll talk about variety of issues which actually doctors face, hospitals face, or even the healthcare companies face. So we'll talk about them, but we'll also talk about that what are the misunderstandings, which are the judicial forums, what are the common mistakes which is normally done by even a hospital administration or establishment or doctors, what are the insurance related issues, what are the ethics issue which govern the medical fraternity. And with this background, we'll try to sum it up in 45 minutes to 50 minutes. And after that, we will interact with you people on questions, and more questions will come, and that will give us a clarity which way we can further demystify the whole concept of medical negligence. So, without much time, I'll straight away bring Chakrapani to introduce himself properly and also tell us that what he thinks about medical negligence, where India stands today, and what are the new changes you want to hospitals and doctors to embrace. Chakrapani Mishra.
Thank you so much for that very kind introduction. I don't think I'm going to add anything more. Anvesha and you, sir, have already given very kind introduction. I remain a student of law and practitioner of law for last 27 years. And I had the privilege alongside some of our eminent colleagues, some of you here, to see how this law has developed and also like how there has been shifts or waves, if I may say that sometimes the judicial thinking has gone more into the side of the doctors, or sometimes it has shifted towards the so-called fashionable consumerism. So it has been quite a journey, and it's like still a work in progress, if I may say that, compared to the more developed economies, as we see that in terms of US or other economies, where we see that law has developed and there are specified statutes created for specific situations. As against that, we are left to fend for with what is common pool of jurisprudence, whether it be CRPC or whether it is the IPC or whether it be Consumer Act, which is supposed to be more for a generic purpose. The same acts are being used for this specialized nuance. And it kind of tends to victimize sometimes the doctors and hospitals, and it sometimes veers into that fashionable, which very recently Karnataka High Court judgment said that its doctors need to be protected from this damages and compensation culture which has crept in. So that's what it has been. That's the litigation, that's the jurisprudence so far. So we have our criminal procedure code, we have civil procedure code, we have consumer court, this thing, and of course the medical council and medical commission. So that's the broad framework of law. The judgments that we have seen coming out initially, of course, that under the old Consumer Protection Act, we had that famous judgment which brought doctors inside the ambit of Consumer Protection Act. And luckily, that part now is kind of diluted, but that is still, there still remains a confusion after the repeal of the old act and 2019 act coming into play, where they have omitted to include doctors, which is a good thing. However, they left it very vague, and it's an inclusive definition of consumer. And that kind of creates a problem, though recently, if as we all know, Supreme Court refused to take that doctors are included in the new act's definition of consumers or within the act. However, there is a very recent Bombay High Court judgment which has actually brought them back and said, no, actually, because this is an inclusive definition, it has to be, it has to be read into. So these kind of things, in my view, they create confusion. We need more clarity. We need clear laws governing the field, because it's a specialized nuance field.
I
And
agree.
and doctor's profession is a noble profession. You are trying to save lives. If you are trying to here create an atmosphere which is uncertain, or it's an atmosphere where you are constantly in fear of either prosecution or susceptible to damages, is not good for the entire atmosphere as such, and then resultantly for the
I
society.
agree. I agree. So
So,
I'll come back. I'll come back to you because I just want initially to build it up so that I get ideas, Chakrapani. I remember just developing upon what you said so nicely. It was 5 years back, I believe, maybe 4 years back, when dengue had become a huge issue in Delhi, and one of a daycare hospital chain, which had a death in the because of something which happened, and the patient was not brought on time, and then all the TV channels in Delhi, they were showcasing "Hang the Doctor." And that was the kind of narrative which was made. And I was before few TV channels. I said, you don't have that kind of situation. First, this is a very, very ridiculous statement. And secondly, you don't have that many doctors that you can disrespect them even. You have to in any case respect them, but you are terribly devoid of enough number of doctors. So this is one presumption, and Chakrapani, we have discussed it, that courts are now alive to the fact, the district courts and the state consumer forums, and even the when people go for FIRs against without knowing the details, that it is actually for all practical purposes stopped by judicial intervention. You can't just go and file a FIR against a doctor. कि हमारे पास बहुत कम डॉक्टर हैं और हमको डॉक्टर्स को रिस्पेक्ट करना चाहिए, बहुत मुश्किल से वो वहां तक पहुंचते हैं. That's a prima facie, I think. But
Ji,
before I go to Atul bhai, let me just tell you two, three things which are defining us in 2022. You talked about the judgment of Dr. The Karnataka High Court judgment, but there is another one which is actually showing a lot of way to us. And I will circulate, Anvesha, this judgment to all the participants. That in Supreme Court in 2019, Vinod Jain versus Santoka Dularji Memorial Hospital case. This is a Supreme Court reported case, and we are trying to keep it a very little less legal, but this is an important judgment. So there was a standard degree of care. जब हम court जाते हैं, we normally talk about a standard degree of care that a doctor has to take A, B, C, these care in order to avoid a case of medical negligence. Here is a case where Supreme Court has effectively diluted the threshold for fixing accountability in medical negligence case by observing that even in case where a healthcare professional might have made a wrong diagnosis, the same will not tantamount to medical negligence. Now, the apex court of the country has gone on to say that even if it's a wrong diagnosis, because if you have taken the standard degree of care and there is a wrong diagnosis, like any error which happens, then it can't be called a medical negligence. So, what Chakrapani has said that look, now the situation is slowly getting better, not because of the pandemic alone, also because of, you see the judgments of last 5 to 8 years, the judgments are going to a direction where doctors are being protected by the courts by and large, if you have taken reasonable degree of care. Atul, I'll come to you and I will ask you first, in last 10 years, what are the tough cases you have seen? We are first only concentrating on medical negligence part. What are the cases you have seen? Few cases you will discuss, and which are the cases which show you the light that we are going for better protection of doctors? I'm not talking about hospitals per se, I'm talking about doctors. You are mute.
Thank you, Sudur, for the kind introduction. As you have said that I'm an advocate on record with the Supreme Court of India with more than 21 years of experience. And our firm has been handling cases for Medical Council of India and other private hospitals also. So let me begin by saying that way back in 2005, our late Chief Justice of India, Lahoti, Justice Lahoti, in fact, he recognized in his landmark judgment, Jacob Matthews, he said that the medical profession is probably the noblest of all professions. although he was from a judicial background, but he recognized the importance of medical profession, and he laid down very important safeguards to protect medical profession from unscrupulous elements and frivolous litigation. And in last, I can say in last 20 years, the judiciary has also come to a realization that the medical profession needs to be protected from frivolous litigation and harassment from greedy litigants, etc. So there, as Chakrapani has said, that there are a lot of safeguards which have been built, but I can just tell you some of the basic understanding about medical negligence. I mean, there are a lot of confusion about what is medical negligence. The Justice Lahoti, in his judgment, has clearly said that simple lack of care, or say error of judgment, or an accident will not tantamount to medical negligence. So he laid down the ground very clearly in his judgment way back in 2005, and that judgment is still being relied upon in subsequent judgment by Supreme Court and High Court. So a simple lack of care and error of judgment, because he has said that the doctors are also human beings, and there could be some subjectivity in their decision taking when they are operating a patient or when they are taking a decision while saving a life. So the judgment gives enough room to a medical professional, and it protects them from unnecessary harassment and frivolous litigation. And so one example I will say that, for example, there are two sets of procedure for treating a patient, and if a doctor adopts one procedure while and he decides in favor of one procedure, then even if it leads to the death of the patient, the judgment has said that that would not amount to medical negligence, even though there could be a better treatment available at that point of time. So there are cases where we can see that the judiciary at the highest level has come to a realization that the medical profession, even though there could be some aberrations here and there, has to be protected from
Yeah.
unnecessary litigation and all.
Thank you. Atul bhai, we will keep it always like this, that we'll keep on interacting in a very... So I'll tell you
Yeah.
what is the dilemma we face. Uh, I have, and I'm sure my colleagues also will agree with this, that when you interact with hospital owners, when you interact with medical superintendents, when you interact with doctors, what is the expectation of a patient? A patient expectation is the sky, actually, beyond the sky. I'll just give you one example, Chakrapani. A very famous hospital in Delhi. I was sitting with him, the owner of the hospital, one of the good heart hospital, and he said that a patient he actually saved, right. He said Yamraj ke paas se bacha ke le aaya usko. 2-3 days observation, and then he finally came to the recovery room. So he went, because it was a tough operation. He thought it's a good idea to go and meet him. He went to meet him. He said, "How you are feeling now?" Hindi में पूछा उन्होंने, how you are feeling now? So he said to the doctor after thinking a little bit, साहब सब कुछ ठीक है लेकिन यहाँ चाय अच्छी नहीं मिलती है.
Oh no.
So that is the expectation level of a patient for you. I'm just trying to make it just, when you meet the hospital owners, when you meet the doctors, the kind of work which they have done in the pandemic, despite that they have to struggle for something, that they have to come on the roads few times, you have to realize that, one, you need them to stay in our country. Second, you need them to give a conducive atmosphere, which Atul Bhai said very clearly. You also started with this. And so we will go a lot into, first, that how the courts and the judicial system has protected it, and then we will go to the aspect that how hospitals and doctors can take more measures to do some self correction. I will go to that part also, but before that, another interesting judgment which I want to tell our audience, that Dr. Harish Kumar Khurana versus Joginder Singh, 7 September 2021, again a Supreme Court reports a judgment. In this case, court said a very again a Supreme Court judgment, which will be the law of the land. The Supreme Court held that a hospital's and doctor's omission to treat a patient does not automatically make them accountable for medical malpractice. Every death of a patient cannot be, on the face of it, be considered as death due to medical negligence unless there is material on record to suggest to that effect. The mere legal principle and the general standard of assessment was not sufficient in a matter to the present nature where the very same patient in the same setup had undergone a successful operation conducted by the same team of doctors. Hence, the conclusion as reached by National Consumer Redressal Forum is not sustainable. So, judgments after judgment in last 5 years are going to favor doctors and the medical establishment, not because of the pandemic, but much before the pandemic also. That's a given. 3% of total, 3% or less than 3% of conviction on medical negligence cases have happened so far. Our data says that. So, Chakrapani, I'll come back to you and I'll ask you that what are the cases which you will like to cite or which you'll talk about, which asks you to tell the doctors to be cautious, where you feel that, look, these judgments have happened because there was not the elementary care or the reasonable degree of care which was taken?
So again, an excellent question, an excellent point, and I think we cannot overemphasize the relevance of this in context of colleagues who are here and as practitioners of law. So I'll try and distill it into a few sentences as to where the bucket of cases where courts have been very supportive and where cases where things have gone the other way or courts have held that doctor or hospitals have been negligent because of XYZ reasons. So as you rightly summarized, case after case, our Supreme Court has been trying to protect the doctors and say that is not merely that error of judgment, or if there were two alternate options available and one option was chosen, and because of that any injury happens, doctor will be liable. The answer is no. So though that area is cleared. However, there have been cases where courts have come up upon very heavily upon doctors and hospitals. And those cases, the common thread that I find is that there has been a lack of documentation. There has been a lack of proper submission of evidence, and to some extent there has been a gross negligence. So these are the cases like they need to be taken into perspective. Cases where it's not hospital's negligence, but the evidence or the documentation has not been proper. That's a very risky area, and that's where things may go wrong before a court of law, because as we all know, कानून सबूत मांगता है. So we need to have that evidence. We need to have everything documented. Things have gone wrong where documentation has not been proper. Second part where things have gone wrong has been a case of pure negligence, and that is something that probably it's court's duty to balance out. So if I have to distill it and suggest to all here that what we need to do, we need to document and preserve evidence at every step of the way, because that is something that will help a court see the light of the day. A court would see the correct perspective from a hospital or a patient's side, a hospital or a doctor's perspective. That is what needs to be taken care of.
So very well said. And this is exactly I'm going to come now, because even if courts have been very sensitive, even if the judicial system has been very responsive right from the beginning, they understand, and there is a general feeling, whatever said and done, people still think that the doctor is God. He's the next incarnation after God. Despite the fact that you go to these fancy lobby of these large hospitals, and sometime that feeling comes to him that okay, or if he has a bad experience at the reception of a hospital, or he has at the billing office. I know these things because when you cross-examine, when you go to the court, when you see the affidavit, sometimes you try to settle these cases, you talk to them and you meet them, or opposite side lawyers, both the lawyers sit, and you realize that something like wo chai achhi nahi bani is a major cause. And that that kind of, and that's the reason of this panel discussion, that you have to have your soft skill, emotional thing. When you see Patch Adams, I think Chakrapani, you would have seen Patch Adams, Robbie Williams movie, that he was a happy doctor. He was a great doctor who used to spread a lot of happiness in the operations room and other places. And the moment you have a soft skilled doctor in a very difficult circumstances they operate, whether it's a OT or it's a general this thing, it will help a lot. That's first thing which you mentioned, and I'll repeat them. Second is documentation. It's a done thing now that whether you keep it digitized or keep the original file, give them a set of documents. Sometime by some mistake or some bad advice, you don't give the set of document which you should give it to the patient. Even that starts, the first allegation on you is that you haven't given him all the documents. So, and the Medical Council of India, when it was, now it is called the Commission, that mandated you to keep the documents for 10 years. And these are very good observations which have come to us. And Atul bhai, what are your suggestions that हम अपने को self improvement क्या करें as hospital and doctors to become examples, that when somebody falsely makes a case against me in a court of law for medical negligence, I, as a reputed doctor or a reputed hospital, should not suffer a dent in my position or personality.
Yeah, to take the discussion on documentation part, I agree with Chakrabarti that the documentation is very key to fighting a litigation. Because we always look for documents where we can, from where we can take strength while defending party. So documentation part is very important. In documentation, what I would suggest, I would pinpoint is the consent part. When the patient or patient relative is being educated about or being asked to sign a consent form, there it must be done within a proper time frame. It should not be that the patient is in the operation theater and the relative or somebody else is being asked to sign a consent form. And also educating the patient as well as the relative and taking proper consent and documenting it properly, that's a key according to me, because most of the allegations which we notice in our cases that the hospital didn't inform us properly, or they didn't take our consent beforehand. When the patient was already in operation theater, they came and informed that you need to sign this form and that form. So these kind of allegations are galore in litigation. So what I would suggest is that the hospitals, when they are taking consent from patient or patient relative, they should document it properly and keep it, or if possible, they can video record it also, because nowadays with the help of recording and all, if you can record it and keep it in digital form, that would also go a long way in defending a hospital or a medical professional. So I would pinpoint to this aspect, that consent and keeping a proper document and not taking last minute consent or informing relative at the fag end of the, sometimes some of the hospitals might be doing, I don't know, but the allegation is that after the operation was over, the consent form was signed. So these precautions must be taken by hospitals. I believe most of them are already complying with it, but I would suggest if they can keep it in a digital form also, a video record it also, that would help a lot in defending client like hospitals.
Very well said.
Uh,
And yeah, Chakman, please
Sorry,
go
if
ahead.
I come in very
Yeah,
quickly,
sure.
sir, I'll because
Sure.
Atulji made a very good point, and I just wanted to supplement it that all that we need, also when we take consent, we need to be sure about a specific procedure or procedures that are being conducted. Or if it, because sometimes, I mean, I remember that 2008 case of the Samira Kohli, where Supreme Court said that consent taken for one procedure cannot be extended to another. So
Yeah.
that's again a very nuanced thing, and it will be like while we are recording consent, it should be for a specific procedure or procedures so that tomorrow there is no complication or confusion on that.
So well
Sorry.
said. So well said. So well said. And you know, the best part is that we are going into a very, very nuanced discussion now. I'll just tell you another thing that few of the hospitals for which I used to work in 2004 and 5 and 6, uh, this this habit of not taking the documentation seriously or not doing the consent forms very carefully. So consent form is also a very dynamic concept. You have to, the consent form has to go for a yearly review. If you are a doctor or a hospital, your consent form also needs a yearly review. And we have been doing such legal audits for hospitals now where we find that the documentation needs a complete revamp under the new kind of treatment or a new kind of thing. And very importantly, listeners, you have to remember what Chakrapani said, that you get a consent for one thing, it won't be a carte blanche for everything. You can't be using it on a generic basis, which is Supreme Court judgment. I was not aware about it. Going to another judgment, a very interesting judgment from Karnataka, a lot of good judgments there because, and you can guess why so, because there is a lot of privatization of hospitals which happened in Karnataka. And it's always going to be the case that if it's a private hospital which charge money, there is a general feeling that the compensation culture is more there, where people will go against because you have charged them a fee which they somehow feel that it is not totally justified. So it's in their inner thought, like why not to go for a court thing and try to get some money back. That's also a thought which works in the mind of the relatives or the patient itself. Ganesh Naik versus Shamana, Karnataka High Court 2022 decision, very interesting. Here they said that the cases of medical negligence are launched recklessly by the patient and their relatives. So their courts are now knowing that patient comes, he deposits few fee, and then he says at the time of the checkout, like a hotel checkout, he starts negotiating the bill. At least 10 cases I know in a year where they start negotiating the bill, and you don't negotiate, you charge the fee, and they go unsatisfied or angry or upset or whatever. So that leads to some kind of standoff. That leads to some kind of friction. The case of medical negligence are launched recklessly by the patients and their relatives. Compensation culture, which obtains in other jurisdictions, is gaining entry to the field of medical services in our society, affecting a healthy relation of doctor and patient. It is rightly said, faith heals and not the medicine. So the court has gone into a very detailed judgment on this. So they are understanding what is there. Now, what will you do as a hospital? You will have those people who will have better soft skills because your billing, your reception, and I'm telling you, because 30, 40 hospitals, small hospital, big hospital we work with, we know that this is something, how your security guard behaves at the gate and how he reaches right up to OT, that all decides the outcome of how a person finally lands up in a legal notice situation and launches a case against you. That's the situation. I'll come back to Chakrapani again, and then I'll go to Atul Bhai. That what do you what do you think is the way forward? Do you think that regular legal, uh, which called hospitals or any business establishment, normally stay clear out of legal? And the second thing which is unfortunate is that there is a common misunderstanding that even if something happens, you have a legal insurance. And the concept of legal insurance is that when the lawyers come on behalf of the insurance company for a doctor in a court of law, a lot of times I've seen those cases get spoiled because of the kind of effort which is put in those cases. So those are very tricky areas, and there is a misunderstanding there that really protects you very nicely. Of course, the payment can be done by that insurance company, but the reputational issues which sometimes happen are hard to be repaired. What do you think about that, Chakrapan?
As you have rightly summarized, sir, the situation is not happy. And it gets more complicated when insurance lawyers get involved and things like that happen. I I, I don't have any magic suggestion for it, but the way I look at it, couple of things can be done. One is that hospitals and doctors and all stakeholders need to create more awareness about how things will pan out, how things work, what services are being offered, what is expected of us, and what is expected of a patient. So some kind of a standard charter kind of a thing, if it is
Yeah.
popularized and it is kind of shared with en mass and kind of promoted, it will help in a long term to create awareness, because just because you walk into a hospital, don't
Yeah.
expect it for free. And at the same time, there is some duty which is doctors have to perform or a hospital has to perform, which is a standard given. So that's suggestion number one, that it might work. Second thing that I feel is that, and that's, I don't know, I leave it to the thoughts from all of us, and I will also invite thoughts from our members. But
Yes.
I feel mediation may do a lot of good work here, because it's like you are dealing with a situation where it's more emotional than real. So the real dispute may be a very small thing. A person may have died, a patient may have died because of some other ailment, but the family will come and say that because of your negligence, it has happened. Now, hospital or doctor is not going to win in that sense, because it's a loss-loss situation. Once the matter goes to court, you are dragged to court, you are having all those this troubles related to litigation. So even after some time or after a few years, you win, it's still not a win. It creates bad publicity. So I feel mediation may work in a
Very
big
well.
way.
Very well. Very
That's
well.
the second point that I wanted to talk about, that maybe a specialized body or a specialized set of professional mediators who can sit across and try and settle this before it goes out in the court and is dragged one way or the other.
Very well.
And the third thing, sir, is again, I put it for consideration, and it's like we can only wish that there should be a specialized legislation dealing with these situations. And it should not be left to general body of jurisprudence, which I started by saying that it's everything is in one cart. So that these are the few things that I can think of that will help this current situation.
Very well, sir. Thanks a lot, Chitramani. Atul, you will tell me that there is one aspect we have talked about, the consumer forum. It starts with district forum, it goes to state forum, then the national forum. They have amount as a jurisdiction, then they have other things. But there is another dimension. And before I tell you the dimension, that I was working with a company which used to take a lot of cases of doctors, um, where they wanted to know that how much police can disturb them and how much this police nuisance which used to happen. So we actually said that we put an order that unless you get an express order from the executive magistrate, you can't file an FIR. So police has this thing like they will go visit the small nursing homes and other places. You know what I'm talking about. So they actually placed it along with their certificates in their reception area, and it really helped. That okay, you need a order of the court. You just can't come and file or undertake a police complaint. But it is true that police FIRs are filed against doctors in exceptional circumstances, and those circumstances have happened more often in last 5 years. Let me also tell you, the data suggests Gurgaon cotton left in woman's abdomen during surgery. Court directs FIR against doctors January 20, 2022. We are talking about just 2 weeks back. So this happens throughout the country. Happens. My point is very non-controversial here. Police or FIR wale situation mein how do we land up? What we should do to avoid that? Because I'm better off facing a legal notice of compensation, dealing with that in the worst case scenario. What are your suggestions, sir?
See, so far as the criminal cases are concerned, it's not a legal issue according to me, because the legal position is well established that the doctor for a criminal case, in a case of medical negligence, can't be started in a routine fashion. And there are protection which have been which have been given by Supreme Court also in Jacob Matthew case.
Ji.
So when the police comes to a hospital or for certain thing, they don't, I mean, come following the legal procedure. They basically, they are, as you know, given the condition in our country, they come for extracting some extra things. So that's not a legal. According to me, they don't fall under the legal issues, but they fall under extra legal situation. And but I would like to come here and, in fact, point out certain statutory and certain safeguards which the Supreme Court provided to doctors in a criminal case. When a criminal case has to be started, what are safeguards are there for a doctor? The Supreme Court, I mean, in Jacob Matthew case, I'll come back to that judgment because that judgment is a very landmark judgment and it deals with a lot of issues. Supreme Court gave three safeguards. Number one, it says that a private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of a credible opinion given by another doctor, competent doctor, to support the charge of rashness or negligence on the part of the doctor. So first, the complainant who is trying to file a criminal case, he has to come up with another opinion of another doctor saying that this case falls is a case of rash negligence or a gross negligence. The second safeguard, which is equally important, is that the IO or police officer should, before proceeding as the doctor, take a medical opinion of opinion preferably from a doctor in a government service or government hospital who is qualified in that branch, who can give a certificate that yes, it's a case of gross negligence and and a criminal proceeding can be initiated. And the third is the Supreme Court itself in judgment has said this: a doctor, because a charge has been leveled against him, his arrest should not be done in a routine manner unless until the IO is convinced that the doctor might run away or he may not come for make himself available for investigation. So these are the three key safeguards which the Supreme Court in its judgment has given. And these safeguards, according to me, must be, I mean, the hospitals have their admin department and the legal department. These department must keep in mind that these three safeguards, and whenever such situation arises when the police is trying to harass a hospital or a doctor, he should try to tell them that this is the Supreme Court guideline and you have to follow this. If you don't do this, you will be hauled up for contempt.
So,
So we
so
have to take two-pronged strategy. Number one, we don't have to fall prey to these I mean, extrajudicial thing. And the second is that we have to tell the officer IO that you can't proceed further in this matter unless until you satisfy these three safeguards, which have been made available to the law to the doctors by Supreme Court. Otherwise, there is a case for contempt.
thank you. Very well said. So, this is a very important aspect for listeners and viewers who are watching. So, what we are going to do, Anvesha se baat karke, we are going to send you all the judgments which we are mentioning today. And I will suggest this particular judgment, which Atul mentioned about the police being kept at bay for all the right reasons. We'll keep a copy of the judgment. In fact, always let's keep two copies of the judgment in every nursing home or a doctor's place. Like we had done, we had taken out the title of the judgment and we had taken A, B, C, D highlights and framed it actually. I had got it framed in many nursing homes in Haryana and Rajasthan when I was working for a particular company which wanted that kind of help for doctors. So I think what we will do on behalf of NatHealth, because Anvesha, I can see her, so I will take the liberty of suggesting two major things which are the outcome of discussion till now. Chakrapani mentions about a mediation mechanism for hospitals and doctors with the patients also. You know that in our meetings in NatHealth, we have been talking about having a permanent mediation system for all kind of issues where we will have trained mediators. So we three lawyers who are here, we are willing to help you with the mediation mechanism which NatHealth wants to have, and that can be the forum for self-regulation, providing alternative dispute solution and other stuff. That's point number one. Point number two is we'll give you all the judgments. My colleague will be sharing the judgments. She will compiling. Simran will be compiling with Atulji, Chakrapani and my judgments, which I'm mentioning. And some of these judgments can be kept in every nursing home and every place. We are at the last round of our discussion. Few new Chakrapani has come. Few new laws have come. I won't call them new laws. They are basically makeovers. The National Commission, which has replaced the MCI, also the National Commission for Homeopathy, National
Just
Commission
one,
for yeah.
yeah, Sudhir, just wanted to make one point. What we have noticed is that the National Consumer Commission, you will find that they also sometimes have disregarded. I'm saying this with a lot of gravity, that they have disregarded Supreme Court's, in fact, well-established principle with regard to medical negligence. So I am sorry to say, but this is a position sometimes National Commission, because that is why the Supreme Court overturns most of the decisions which have been made by
Yes.
National Commission.
So that is something which is true. That's a larger debate that most of the tribunals have
Yes.
that issue,
Yeah.
whether it's National Green Tribunal or National Consumer Forum or NCLAT. So that's a larger debate for us.
Yeah,
That's
but I wanted to point out
I
because
agree.
most of the
But
cases have come from National
I will
Commission.
agree. But what I am going to do is we will try to show if a Supreme Court has passed the judgment, it's the law of the land.
Yeah.
That's what the spirit of the Constitution
That's
is.
the final code.
So then, thankfully, with the police and other people, they understand that it's the law of the land. So we will stick to that. That's one. So last leg is Chakrapani, that we have these new laws which have come. MCI replaced by a very well-staffed, large number of national commission. How much it is working? You have any comments on that? And these new commissions for Indian system of medicine, I trust it's Ayush and National Commission for Homeopathy. So, you think that these new legislations which have come, of course, National Commission, Health Commission is already there and it is working very closely with NatHealth. Uh, do you think that it's not a bad idea to engage with them on jurisprudence, policy, advocacy aspects, just to also keep them aware about where we are?
Sudhir, can I take one point
Yeah,
just
yeah,
before?
sure, sure.
Yeah,
Sure.
because it's related to my earlier point.
Mm-hmm.
See, the Supreme Court way back in 2005 has recommended for amending the statutory rules and executive instructions, which are required, which should be incorporating these three safeguards against police action. But the government of India has not come out with any kind of a statutory rule or guideline which has been recommended by Supreme Court. If NatHealth can give a representation to the government of India, citing this judgment, saying that these are the recommendations of Supreme Court of India, and this needs to be come out in the form of a statutory rule or is executive instructions also, that will
Very well
go a
said.
long way in
Very,
helping the hospitals and the doctors.
बहुत
That's
बढ़िया.
the one point.
Very good.
So,
Chakramani ji.
so building on what Atulji said, it's I mean, and I'll start with the second part of your question first.
Ji.
It's I would say is our duty as organizations like NatHealth or other organizations to make these representations to the government on time to time basis and engage with them definitely, because these inputs which come from expert bodies or the actual stakeholders as we call them, these inputs will not come from bureaucracy. because if legislation is to be passed, is just standard legislation coming in play, patching up from different provisions of law and so on and so forth. But actual practicality will always come from the inputs of the professional bodies. So it is very, very important that timely representations are made. And I'm very happy to note that many industries now engage professionals like us to take their inputs into a cogent form and then present it to the government or to the commission and
Yeah.
whichever the relevant body may be. And that has actually yielded results because in many cases, government has taken those suggestions, especially if they are well drafted and they are put in a form of a clause, like what Atulji was talking about earlier about that Mr. Jacobs case of 2005. Those guidelines, if they are put in some kind of a draft legislation or a suggested legislation and presented, they probably would find place in some legislation. So it's very, very important that organizations do engage with commission as well as government on a very timely basis. There is no other way of dealing with it. So that's one part. Now coming to commenting on this new act or new laws coming in. It's it's ironical because in our country, legislation is 50% the old wine in a new bottle, and that never helps. You need to. It's nothing against new or old. It's all
Yeah.
about you need to move on to the reality today. You
Hmm.
need to move on to like there has to be like you need to address issues like central registrations or right to practice across or things like that. You need to come to the next level. Then only these legislations have meaning. Otherwise, it's just parking with great respect, parking berth for some bureaucrats and or officials. Then it has no meaning. So in my view, it's not
Yeah.
very path-breaking. It's nothing great that is happening unless issues actually pertaining to the industry are addressed.
Hmm.
It's nothing much.
Great. And
With
just
respect.
wonderful. So I'll now come one by one to all of us. And you know what I was thinking? What are the points which I remember, which I have told hospitals and doctors regularly before a case situation or a legal notice or a suddenly something which comes against us? I realized two, three observations I have. One observation is that doctors have to be ready today to deal with the digital patient. You have a digital patient sitting in front of you who has a mobile and he's taking all your views. He's discussing with you. He's paying 1,000 rupees, sometimes 1,500, 2,000, 3,000 consultation charges, and he's actually recording you. All your points, he's recording you. And then what happens when we talk to, and this was not the situation 5 years back. You didn't have those cameras, you didn't have these devices, you didn't have this kind of deficit, trust deficit also. I am saying it because there was a case where each and everything that person recorded, and now it's a recording between me and him. It's not a third person's recording. So I'm only saying that I have a proof that doctor had promised me that this will happen, this will be cured, and 100% cure hoga iska. So what I'm saying, we have insisted on many hospitals, many OPTs, doctors' chamber, that please you say very clearly that mobile use is strictly prohibited. जैसे हर जगह लिखा होता है, प्लेन में लिखा होता है, ऐसा ये आप कैसे करोगे, मैं तो बहुत सिंपली बता रहा हूँ. But there has to be a system that you have to be careful that the patient should be trusted, but you should have your due mechanism now. That's one. Second is writing of prescription. Now there is a patient where we were dealing with a case. He comes or she comes to you, and you say how many weeks back you had come. I'm talking about a pregnancy gone wrong and a medical negligence case. So she said, I came 6 weeks back. You wrote on the prescription 6 weeks back. You are actually following what that person is saying. because there is no earlier mechanism. You haven't recorded, you have no track. He comes with a new or a lot of people actually don't carry the same prescription also. So you trust and you say, tell me, when did you come? Again, it was used by me. That person was used it, and then we had to really say that no, this was not the prescription, that was other prescription. That's true. And second is legibly, when you write and you write anything, and the consent form issues are very very important now. That you can't say, अरे मैंने तो उसको बोला था कि आप इसका अल्ट्रासाउंड करा लो. अब आपने बोला था, but you didn't actually put it in writing that you do a ultrasound. You did it in trust, verbally. Later, she said that, look, I have such a huge thing inside. You didn't tell me. You didn't recommend ultrasound timely. So I would say थोड़ा क्वेश्चन अगर हम रखना शुरू करें तो ये प्रोटोकॉल्स को थोड़ा सा रिविजिट करने की जरूरत है, because a lot of pressure is there on the hospitals and doctors. This is one. And the second part which I want to say, the doctor and owners of hospitals relationship. A lot of cases we have said in initial period, both of them will walk in my office, Chakrapani, and and the promoter of the hospital will say that, look, we don't want to be liable. We deduct tax at source. He's a consultant to us. I say, how can you deal with this situation? You can't say like a Uber that I have provided him just a software space. So these are the tricky issues, because you take a stand, you want to protect everybody, the hospital and the doctor, everybody. So how do you deal with these issues, Chakrapani?
Steve, you have very well summarized the problem, and few things come to mind. One is that, I mean, starting with the mobile interactions. One is that, of course, you protect your mobile. You say that there will be no mobile communications. Second is that if you can't avoid it, then it's important that every doctor or every person who is facing the camera is trained to have certain, uh, certain basics in place. Like,
Avoidable.
yeah,
Yeah.
do not commit to something that is not possible,
Yeah.
or do
Yeah.
not say things which we say generally in casual communication. हाँ साहब हो जाएगा, don't worry, मैं कर
जी.
दूंगा, या I will take care of it. Don't say those things. So there may be some training that will help.
जी.
Similarly, when it comes to, then probably there can be a disclaimer in the beginning that this is advice is general in nature and it's only for the sake of a basic advice which is being given. And if you need a specific advice and a specific, then please come and consult in person. Some kind of disclaimers can be drafted by professionals and used in that call, so that will help.
Hmm. Yes. Atul bhai, what are your thoughts?
See, what I would say is a lot of issues are already covered under the IMC ethics regulation of 2002. As you said that it says, in fact, if I can read out from that, regulation 1.3.4 says that the effort shall be made to computerize medical records for quick retrieval. So, whatever medical records are there with the hospitals, I believe most of them are doing that. But there is this is already provided under the regulation, ethics regulation. And also now under 1.5 of the regulation, it says that every physician should prescribe drugs with generic names legibly and preferably in capital letters. So whatever you are prescribing, that should be can be clearly seen by the patient or by any third party. So these a lot of in fact medical IMC ethics regulation 2002 has a lot of such issues covered. And also one of the issues which Chakrabarti mentioned, that it says that when you are taking a consent or when you are discussing with the patient, you should tell him the exact position of his health condition. You should neither minimize the thing nor exaggerate his medical condition. You should tell him what is his medical condition, and that's why I'm saying that when you are doing all this, it is better if, I mean, it can be recorded. That would be help a lot, because that will go a long way in defending cases before court. Because then you have all the evidences before the court, and court will also appreciate that, because unless until you have something to hide, you will not produce all these records. I mean, you will produce all with digital records, everything. So I would suggest that in the coming, I mean, next decade or so, digital records will play a long, digital recordings and digital even evidence in the form of digital recordings will go a long way in helping doctors as well as hospitals. And I believe a lot of technological developments have also taken place, so that will help the hospitals, because most of the cases can be won on the basis of evidence. If we have proper evidence with us, we can defend them in a better manner, because sometimes we find difficult because of lack of evidence. If we have proper evidence, we can always defend them, because especially when the courts and the highest court have taken a view that the medical negligence can't be slapped, a case of medical negligence can't be slapped on doctor in a routine manner. So a lot of protection is coming from the judiciary side. If we can supplement it from our side also,
Yes.
in the form of collecting proper evidences and documentation, keeping it in a digital form, that will help a lot in overcoming a lot of medical legal cases where we are fighting.
Great. Thank you. I think we had an excellent panel discussion till now. And Anvesha ji, we are ready to welcome questions. We have finished it almost on time. And we are very happy to welcome questions now.
Yeah, so people have actually started writing questions in the chat box. If you can open the chat box, I see some people have already put up their questions there. Maybe you can take
Okay.
one by one, and I'm requesting the audience, you can either write
I
in the
can
chat
read them. Huh.
or raise your hands and you can directly interact with our speakers.
Okay. So Dr. Amit Kumar Gupta has asked a question. If a doctor provides consultation to a couple where the husband's HIV test is confirmed positive and wife is confirmed negative, and the husband does not give consent to the doctor for revealing his HIV status to his wife, whether the doctor can reveal it to the wife, because if the doctor reveals without consent, it would be breach of patient privacy. And if the doctor does not reveal, it would be a gap in the doctor's duty to care for the wife's health risk. What is the legal stance here? Thanks. I think it's a complete legal opinion, Anvesha. Atul bhai.
Yeah, see, under the ethics regulation, there is a secrecy aspect of, I mean, patient secrecy, I mean, his medical record, everything has to. But at the same time, it cannot be at the cost of some other individual or individual rights. So, in my view, if he reveals the condition, because it will save the life of other person, judiciary will not find fault with this, according to me.
Okay, so we will have brief responses. If you want a detailed response or something, then you can write one-to-one mails so that we can accommodate everybody.
Yeah, Anvesha, you can compile all the, I mean,
Questions, and we are
questions
happy to
that
give
then.
detailed replies. Telephonically, they can also talk. Anvesha, that's the purpose. I'll go to Dr. Lata Venkateshan's question. Very interesting question. Chakramani ji, private hospital have different tariffs for insured and non-insured patients for the same procedure. Is it legal? So before you say, I will also include in this question CGHS also. Central government health scheme also has same procedure, but you charge even less than the insurance sometimes. So how do we say, is it legal? Of course, it is legal because it is being done.
See, you have already answered it. It's in that sense it's legal because it's happening. However, the way it is like, if it is a class of cases, if it is like, if it is a clear class and there is a reasoning behind it, and in that class there is no sub bifurcations, then I think it will be fine. The hospital will be able to justify it. But there has
Yeah.
to be some justification for it as to why this is different and what exactly it entails. So there has to be some documentation or some policy which hospital we generally advise that they should have a policy or some clarity or some in documented form to be kept at the back end, because it cannot be, if it is termed by judiciary as discriminatory, then it may have a question mark. However, if you have as a hospital policy, you say that because of XYZ reasons, these two differential tariffs are being charged, then it will be sustainable.
Very well. And I will add to this that if you see the vaccine price, when the private hospitals were allowed to charge a particular sum for the same vaccine, which the government was giving free, so I would say that would also qualify in the same way. And now it is going to be available in the market. You can buy over the counter. So it will be priced even more higher than that. So these things are not only legal, illegal, they have a lot of other bases which where their foundation lies. I will come to Vasundhara Atre's question. If communication between doctor and patient is confidential, why is a recording to which the doctor has not consented admissible in court? If a doctor needs to record, he needs to inform and take a consent. A lot of time, the recording are at a point in time and do not communicate the entire story. I would reply to this that, look, honestly speaking, we are not even suggesting that anybody records it. I actually feel that what you need to do is, if you record anything, I believe both the parties need to say, look, I'm recording so that I can remember it for my treatment. And the doctor has to agree to it. Similarly, doctors recording it, I have not heard about it, that doctors have actually started recording what the patient, they do have that much time. I truly don't believe in so. But I think recording per se is not something which is advisable. And a lot of places now, boards are being put that please don't record it. But if you want to discuss more on this, we are happy to reply. I'll take the next question, um, which is Ashish Banerjee. This question is, also in military hospitals, are they liable under Consumer Protection Act for ex-servicemen who are member of ECHS, but this insurance money does not pay to hospital concerned or government? Atul bhai?
Can you repeat the question? I can't. Didn't hear it.
Also in all, Ashish Banerjee is asking, also in military hospitals, are they liable under Consumer Protection Act for ex-servicemen who are members of ECHS, but this insurance money does not pay to hospital concerned or government? Basically, he's asking military hospital is covered under Consumer Protection Act.
Yeah, see, only thing that he's saying that there's no consideration, no fee paid for for
Then
the
it won't
treatment.
be. Then it won't
Yeah,
be.
it wasn't paid, but deficiency of service will still cover it if there is a
Okay.
deficiency.
Okay. But if there is no consideration paid, then the basic purpose of Consumer Protection Act will not be
But it's still
fulfilled,
at the
right?
corpus, at the aggregate level, the
It
government
is
must
being
be
paid.
paid.
Then it is there. A little detailed question, and I think again Atul Bhai has to answer because he understands regulator better. I had sent a specific question regarding the state council asking doctors to register in a state.
Yeah,
Profession of medicine is concurrent subject, and central
yeah.
access method.
I'll answer
You
this.
have read it, so you answer it.
Yeah, see, the public health is in the state list entry. Okay, entry 6, if I remember correctly. And medical education and medical profession is on the concurrent list. So both under the concurrent list, both states as well as union has a right to legislate on such entries. So using that entry, the central government has legislated on the issue of medical profession, and since doctors fall under the is under the category of, I mean, it's a medical profession, so the central government is well within its rights to legislate on it. But at the same time, the public health comes under the state list. So there the state governments are also authorized to legislate because they have to take care of the public health at large. And under that's why a lot of state medical council acts have been enacted in various states. So utilizing public health aspect, the states are allowed to legislate, and being since medical profession and medical profession is a concurrent list, the center has legislated. But unless until both contradict each other, both can survive, both can exist, coexist. So using this, constitutional Article 254, unless there is a repugnancy between two acts, both can survive. If one contradicts the other, then the central act will have primacy. But since both provide for the same kind of arrangement and they don't contradict each other, so they both can survive and both will be in existence. And since state, he has also talked about registration under the State Medical Council Act. If you see the National Commission and NMC Act also 2019, it
Hmm.
allows both, means national register as well as state register for doctor and medical practitioners. So both will coexist, and there is provision for synchronization of records between the state and the center. So and lot of disciplinary action also as taken by state medical councils. So it becomes important that they also register under that. But then the states are well within its right to legislate
Thank
on
you.
this.
Thank you.
There's no contradiction as such.
Thank you. Chakrapani, this is a question by Mr. Kailash. Does the doctor have a legal protection if the audio gets recorded without his or her consent? I know this has come out of our discussion only. So, good idea. Yeah.
Sure, sure. So the short answer is that if you can establish that it is recorded without your consent, that should protect you, because then you can always then claim other things, that it is not enough, it is not complete recordal of facts, and it is not obtained by consent. But you'll have to prove that, and that's what in our discussion we pointed out. Put caveats or put a disclaimer that this is, I'm not consenting to any recording. I hope it's not being recorded, something like that. Or put a, if you are having a interface through electronic media, then put that disclaimer first, or follow up with a small message or email. The discussion was only to help a patient, and it is hope it is not recorded. I have not authorized any such recording, and the same will be, if it, it will not be usable against me. Something like that will help. So the short answer is, if you can establish that it was done without your consent, then it will, then you have your protection. You will have defense.
Yes. And I think one of the first defenses which we will build upon, my suggestion, which I have given to many doctors in hospital, small nursing home, almost 4 years it's going on, that you put a placard in your room very clearly saying that recording is absolutely prohibited. So you can always take that and just once it is there, it's very easy. Put it at most appropriate place. So it is always easy to talk about it. Very interesting question I have got. Ruchi Ranawat, many times a patient is very critical, on ventilator with all aggressive treatment going on. Patient is also at the end of life care at times, and same is being counseled to the family, but they want to continue all aggressive therapy and all have also have financial constraint. They do not clear their dues, and medically hospital doctors have to continue treatment. How can then the hospital safeguard themselves in such a case where the patient family refuses to pay? Now, before we answer, I'll tell you that during COVID, this has become even a bigger menace. A lot of places this has happened, that since patients were not meeting the family members, a lot of time these payment issues have come in many hospitals. They have taken a human approach in most of them, but a lot of losses are being suffered on this count. That's point number one before we answer. The second thing is, a lot of time patients have actually uh, taken the patient's relative have taken the body, and they've said we'll pay you, and they haven't paid. We have cases, such cases where I have actually filed recovery petitions, and in few of them we have succeeded as well. It's in Delhi and also in National Capital Region. Atul bhai, tell me about the moral, ethical, and dilemma first, and then the legal position.
See, as per the ethics regulation of 2002, a doctor is bound to save the life of a patient. It can't be dependent upon payment of his fee. His first duty is to save the life of the patient. So far as the fee is concerned, that can be recovered through other mechanisms which are legal mechanisms under recovery and all, but it can't be dependent upon payment, and the saving of life can't be dependent upon payment of fees. That's under the ethics regulation also. That's a duty cast upon the doctors. So we have to go by in that fashion. That if there is a patient who is lying in operation theater and he doesn't have a money, and and then the hospital should not and cannot insist on payment of fee, and then the operation will go ahead. If the patient has, you have accepted the patient, you have to treat him, and then you through other legal mechanism and recourse you can recover the fee, and that's the position.
Yeah, because the problem, so that's a legal position, but we need to find a more practical solution because viability of the hospital also becomes a serious issue in this. Again, we gave an answer with regard to the registration of profession of medicine is a concurrent subject. Atul bhai, you answered that, but there is a supplementary question by Nitin. Then, how does a doctor deal with a situation where he wants to practice in two or more states, but each state demands to register, and previous state will delete doctor's name from its register if he gets registered in any other state? So, Maharashtra Medical Council does it, he is saying. Any more comment on this? Because this is something which a doctor is asking, so we need to understand.
Yeah, I will answer that. See, this situation basically why we'll have to understand why a particular state medical council insists on registration under its jurisdiction under the state, because a lot of disciplinary action are initiated by the state medical council in cases of medical negligence and all. So they want to have a uh, say with regard, they want the doctors to register with them because evidence, everything will be available in that particular state. So that is why it is there. Since a particular state insists on the state act, state medical council act, has a provision for registration under its act, it has to be complied with. I don't see any other option for not registering with the particular state medical council if a doctor is practicing in that state, because of the compulsion, because of the provision under the local act.
Hmm. So, thank you, Anvesha. I think I have dealt with all the questions which we have received. And if you have any other question, we are very happy to answer. Or we can conclude the seminar today. It was very exhaustive, very detailed. All of us have talked a lot. And some of the, before we sum up or you sum up, I'll just say two, 3 points. We have learned a lot with these questions also. We can create few standard recommendations on behalf of the lawyers who are part of the NatHealth as a common paper. Chakramani said a very important thing today, which is a takeaway for NatHealth, I believe, that sometime government listens to if you well research something, create a proper research, a policy document which legal has weighted it properly. And those legal, like a person like Chakrapani and Atul being here for such a time, they give very advice which is based on 20 years or 30 years of standing. So if we can create those documents will be really very pushy in nature, and that will give a government also enough legroom to decide about implementing certain suggestions. So that's one takeaway. The second is my team will compile with both Chakrapani and Atul, and I'll give you a combined list. That's my promise of all the cases. And what we can also do that every month, at least three of us can informally send you one judgment that which you can use it in 3 lines or 4 lines. We'll just give you a 3 line Twitter kind of thing that this has happened. I assure you on behalf of all three of us that we'll give you one judgment every month, which is like universal, good for everybody. Uh, Chakramani, your thoughts?
Uh, few things. One is that before any, I will be failing in my duty if I don't express my gratitude for this invitation and sharing this platform with both of you and the entire audience. Thank you very much. And as you rightly said, very learning experience in terms of questions and in terms of discussion. And what I hear from you, we all are law students for life, so we keep learning. I would only conclude with one thought only, since we have already spoken a lot, is that times are changing. And especially with the advent of digital platform and electronic this thing media evolving on a breakneck speed, there is a lot of disruption in every field, and medical field is no exception to that. So please be aware of it. Do not, as a practitioner or as a hospital, do not be steeped in tradition which goes 100 years and then you say, मैं तो ऐसे ही करूँगा. So that
जी.
will not work. Please involve professionals, have good professionals on your board, engage with them, listen to them. For example, as you said, sir, that there should be a compilation of important judgments kept at the reception and at the prominent place. Like Atul Bhai mentioned so many important nuances about the rules which are changing or which are already there to protect in terms of that ethical or moral issues. Those should be adhered to, kept handy, and also kept in tandem with the changing scenario. For example, if there is an online discussion, you need to have a platform, you need to have a proper strategy in place to how you are going to interface on an electronic media, whether you are a doctor, whether you are a hospital, or whether you are just a individual practitioner. So it's very important to keep in tandem with time, take professional help, provide feedback to organization like yours so that it can be compiled together and be passed on to government as a consolidated feedback. So that's all that is. It has been a pleasure
Yeah,
being
it's
here.
wonderful. Atul bhai, your
Thank
thoughts?
you.
Yeah, I just 2 points. Uh, See, Nat Health, since it's I mean, organization which represents most of the hospitals and doctors and all, I would suggest that not only at the central level, at the state level also, if you can give representation to respective state governments, because the mandate of the Supreme Court judgment, if you see that Jacob Matthews, it also says not only a central government, but the various state governments, they are required to come up with regulations protecting the doctors, I mean, from arrest, etc., etc. So at the state level also, you should make effort. Even if you are successful in one or two states to begin with, that will have a catalyst effect, and that you can I mean, work on that. The second issue which I feel is also very important in coming few years would be data protection, because see, a lot of data with regard to patients and all, they are collected by hospitals, and these are personal data about their health condition, etc., etc. So there should be awareness, in fact, campaign by NATHEALTH with regard to collection of data of patients, so that a lot of in future there could be a lot of litigation with regard to collection of data by hospitals. This I can because a lot of the trends overseas in overseas jurisdiction in Europe and America about data, because a lot of patients and individuals are they are very cagey about their personal data. So data, according to me, and they already there's ongoing data protection bill. So we should have another session on data protection and how hospitals and health organizations should go about data issue. According to me, that will be a big issue later on, because already, as we know, data is the new oil now. So data about health condition would also will also assume a lot of importance in coming years.
Great.
And thank you for this opportunity. I really enjoyed it interacting with all of you, and also, in fact, refreshed my memory with regard to many legal issues. Thank you very much.
Thank you. Mr. Mishra, do you want to say anything, your last words, before I
My
give a
word,
formal vote of
my word,
thanks?
my last words are, Anvisha, that I'm thankful to you for first bringing me as part of Net Health, and secondly giving me this opportunity to get such accomplished people in my panel. And it would be a great thing to do it in the future too.
Thank you. Well, it was a very fantastic session, immense learning. I personally learned so much, and I'm sure our participants would have also learned. And, many thanks to our participants as well. Such interesting
Yes.
questions, that they shared with us. Of course, and so many key takeaways have come. We will definitely work on some session on data protection. That sounds very interesting. And even the judgment part that you said that, we will share whatever judgments at least every month. That is something that we can definitely start. We can also put it on our social media platforms. And, we have recorded this session. So definitely we are going to curate a report out of this, which we'll be sharing with
Wow.
you all. So once again, thank you.
Thank you.
Thank you to all of you, to Mr. Mishra, to Mr. Chakrapani Mishra, Sudhir ji, and Atul ji, and to our audience as well. And I just want to tell to our participants who
Thank
have
you.
joined, in case we were not able to answer your questions, and Mr. Mishra, Sudhir
Yeah.
Mishra, and Chakrapani Mishra, and the panelists have already said that you can actually write those questions to me, and we'll get them answered
Absolutely.
through our speakers. And just some announcement, we'll get back again with another set of panelists in about 2 weeks' time to talk on sustainable options for increasing hospital profitability. So if this is of interest to you, please reach out to me. We will definitely be sending out an invitation with registration link and all. And other than this, there is ABDM series that NatHealth is already conducting with NHA. And tomorrow we have a session with Dr. Kiran Anandam Pillai on how can integrators leverage ABDM platform. It's at 4 p.m. Um, so please register and join the session. It will also be live telecasted on our Facebook and YouTube channels. We also have India Africa Vaccine Summit on 11th of February, and our annual summit, the NatHealth annual flagship event on 24th and 25th of March. So please block those dates and register and please subscribe our NatHealth YouTube and Facebook channels. We keep on uploading all our sessions, recording of those sessions on our Facebook channels. So just keep liking and subscribing us. So till then, thank you. Thank you so
Thank
much. You
you.
all have
Thanks
a
a lot.
wonderful audience and
Thank
wonderful
you. Thank you.
panelists.